Morning, everyone. I'm Con Alexander. I'm a member of the Charities team at VWV. Thank you all very much for taking the time to join today, where we're talking about charities and trading subsidiaries. And I'm just going to start up by explaining what we're going to cover. I'm hoping that today will provide an introduction to those of you whose charities perhaps don't currently have a trading subsidiary, you want to understand more about it, but also as perhaps a refresher or an update for those of you who do already have and operate a trading subsidiary. So I'm just going to put my, turn off my camera just because I find it a bit distracting to see myself while talking. So trading subsidiaries, what we're going to cover are what is a trading subsidiary? Very basic question, but I think useful just to talk about a little bit about that. Why might you need one? How should you actually go about establishing and operating a trading subsidiary? And then what are the key risk areas? And then that's going to be informed throughout really by the guidance which is available from both Revenue and Customs and the Charity Commission. And at the end of the slides, there will be some links to what I think are the most relevant pieces of guidance. And as Ellie said, the slides will be available a few days after the webinar. So let's talk first about what is a trading subsidiary. It's almost inevitably, in my experience, going to be a limited company. It could be a company limited by shares. That would be the way in which a standard commercial trading company is established. It could also, in certain circumstances, be a company limited by guarantee. So it has no share capital. It still has a membership, which I'll come to in a second. And the choice, if you're setting up a trading subsidiary, between whether you make that a company limited by shares or by guarantee, will generally be driven by the way in which you wish to fund the trading subsidiary to carry out its activities. As a company, it is going to confer limited liability on its directors. In very broad terms, that means if there are claims against a trading subsidiary from, say, third parties for breach of contract or by employees, that those claims are going to be against the company itself with recourse only to the trading subsidiary's assets. The key legal document is the trading subsidiary's Articles of Association. That's the document that sets out its governance arrangements, and I'll come back and talk a little bit more about the articles a little bit later on. One key point is that it is an independent legal entity in its own right. It's got two tiers of governance, as you would expect with any company. It has a group of directors who are responsible for its management and control. They have a range of duties in much the same way as a charity's trustees are responsible for the charity's management and control. And then the second tier of its governance is obviously it will have a member or a shareholder, depending on whether it's established by way of guarantee or with a share capital. And in the context of what I'm talking about today, I'm going to assume that the parent charity, as I've referred to it in the slides, will be the sole member or the sole shareholder. It is possible, and we do see examples of charities that essentially enter into joint ventures with third parties, and that joint venture is is established by way of a subsidiary company, which is perhaps partly owned by a charity. That raises some different issues. So I'm really focusing today on wholly owned trading subsidiaries of charities. For reasons which I think will become clear, a trading subsidiary will not itself be a charity. Again, we do see examples of charities which have charitable subsidiaries. Again, the range of issues raised by that are slightly different to the issues I'm going to be talking about today. So I'm really focusing on non-charitable trading subsidiaries. Sometimes one does see a trading subsidiary set up with community interest company or CIC status. And that's usually where the charity wishes to give the trading subsidiary some kind of social enterprise flavour or branding, because obviously CIC status brings with it the concept of an asset lock, which may be what the charity wants to achieve. So as a company, the trading subsidiary will be registered with and regulated by Companies House. That's quite a light touch form of regulation. And it's not directly regulated by the Charity Commission. And I've said not directly regulated because, of course, where a parent charity sets up a trading subsidiary, its interest in that that company, whether it's the shares or the membership of a guarantee company, is essentially an asset of the charity. So it is relevant to regulation by the Charity Commission, and certainly the relationship between charities and their trading subsidiaries is something that is of interest to the Commission as a regulator, hence the guidance that they've produced in this area. And then just for completeness, of course, a trading subsidiary is going to be subject to the usual accounting audit requirements for companies. Typically, though, as a wholly owned trading subsidiary of a charity, its accounts are going to be consolidated with those of its parent charity. So why might you need a trading subsidiary? There are essentially two main reasons. The first is to do with tax, and the second is to do with charity law and the Commission's approach as regulator. And I'm going to talk about each of those in a bit more detail in a second. But just to flag that key concepts really in this space from both a tax and a charity law perspective are mitigating risk and also thinking about any operational efficiencies and benefits that might come with setting up a trading subsidiary. But let's talk first about tax. Now, obviously, I'm sure you'll all be well aware that charitable status brings with it access to a pretty wide range of exemptions and release from tax. The position as regards tax on trading income is relevant, very relevant here. Trading income, there are a whole bunch of cases and principles around what constitutes income from a trade. The revenue would point to what they would call the badges of trade, and there are a few of those, but they are things like: are you doing something which is done on a repetitive basis? Is there a profit motive? Is there an intention to trade? And the key point really as regards charities is that they are exempt from tax on trading income, trading profits, which are, and the phrase is usually regarded as primary purpose. And what that means is essentially that the nature of the trade directly advances the charity's charitable objects, or it's ancillary to that. So in terms of the direct advancement of a charity's objects, this would include, for example, where you have a charitable theatre, which is selling tickets to people to come and see its productions. That's clearly a trade. The profits derived from it are going to be potentially liable to tax, but no tax will be payable because it is a primary purpose trade. By selling the tickets, they are advancing the theatre's charitable objects, which is probably going to be promoting the arts. Primary purpose income also includes, as I've said, where the trading income is the activity is ancillary to that primary purpose. So again, thinking about the example of a theatre, if the theatre is also running a bar or a cafe, then to the extent to which people coming to see productions are able to use that, the income that's generated from that activity will also be primary purpose. And as I've said, any profits from that will be eligible for exemption. The position is different in relation to what's called a non-primary purpose trade. And that is essentially where the activity does not directly advance the charity's objects, and it can't be said to be ancillary to the advancement of those objects. So thinking about examples of that, this could be, for example, a charity which has a range of conference facilities which it typically uses to, I don't know, advance perhaps an educational object. If actually it's going to be making the conference facilities available to third parties for something which is completely unconnected with its charitable objects, that is going to be non-primary purpose trading income, and the profits generated by that are going to be liable to tax. Just for completeness, there is an exemption for what's called small-scale non-primary purpose trading income, and that operates on a sort of sliding scale basis by reference to a charity's gross annual income, and in essence, if a charity's gross annual income is more than £320,000 per annum, then any non-primary purpose trading income up to £80,000 will be exempt from tax. And many charities do rely upon, in my experience, that small scale exemption in order to ensure that they're not paying any tax on those non-primary purpose activities. But where that exemption isn't available, this is where obviously the use of a trading subsidiary becomes very relevant. And the way in which it works is really as follows. The trading subsidiary conducts the non-primary purpose trade. It is, of course, it's not a charity itself, so it's liable to tax on the same basis as any other commercial company. So it's potentially liable to pay tax on the profits it generates from that non-primary purpose trade. But it is able to donate all or part of its profits to its parent charity, and it can claim a tax deduction in relation to that. So the net effect, if all of that works well and perfectly, is that the subsidiary carries out the non-primary purpose trading activity. It donates its profits, probably on an annual basis, and it claims the tax deduction. So essentially, the parent charity benefits from the non-primary purpose trading profits free of tax. If all of that sounds a bit too good to be true, and you might have a question in your mind, well, isn't this just a form of tax avoidance? I think the short answer is that this is essentially HMRC, I've put in quotes, approved tax planning. And the reason I'm saying it's approved is because the Commission have some fairly extensive guidance on how to set up and operate a trading subsidiary in a way which meets their requirements. And again, I will come back to some of those requirements a bit later on. But in that sense, it is approved by HMRC. It's clearly also recognised by the Charity Commission as a legitimate way of seeking to minimise the tax that is payable around on the activities carried out by the trading subsidiary and for the benefit of the charity. The second strand, charity law and regulation, and this is where the Commission's guidance, I think, is helpful. This is their guidance on trading by charities, which is CC 35. That there'll be a link at the end of the slides. Not particularly long, quite helpful. Definitely worth a look if you're thinking about the whole question of operating a trading subsidiary. And in essence, the Commission's view is that where non-primary purpose trading involves significant risk to the parent charity's assets, then that trade must be carried out by a trading subsidiary. They also recognise that it can have tax benefits, and they also recognise that it may actually help to bring some operational advantages, in particular perhaps enabling the board of the trading subsidiary to focus very clearly on the non-primary purpose trade. In terms of what significant risk means, the Commission's version of that is essentially whether the non-primary purpose trade risks running at a loss, and that's essentially their benchmark. But they do recognise that's very much an assessment which involves a judgment by the parent charity's trustees. So they're going to need to be looking at the size of the parent charity in terms of its financial assets and financial standing, the nature of the primary purpose trade, the projected income and costs, and things like sensitivity to changes in the market in which the trading subsidiary is running. So it is at the discretion of the trustees to decide whether there is a significant risk, although of course in most cases the parent charity's trustees are probably going to be thinking very hard about the opportunity to ensure that any tax liability on the non-primary purpose trade is mitigated to a significant extent. I just wanted to say a little bit about the expectations of both the Commission and the Revenue in relation to the relationship between a parent charity and its trading subsidiary. And there are probably two connected but key concepts really that they both major on. The first is that it's important to recognise that the parent charity and the trading subsidiary are independent and separate legal entities. And connected to that, that there needs to be an arm's length relationship between a parent charity and its trading subsidiary. I'm going to come back to an aspect of that shortly. And what's particularly relevant there in terms of the Charity Commission's approach is their guidance on charities with a connection to non-charities, which provides a range of guidance on the Commission's expectations in relation to how that relationship should be structured. And it's very clear in that guidance that the Commission expect it to apply where a parent charity has a trading subsidiary. It's also worth recognising, I think, that the trading activity that the trading subsidiary will carry out, that can vary pretty significantly from case to case. And there's probably a spectrum there. At one end, you might have, for example, a charity which wishes to leverage its brand and its name by, for example, licensing that brand to third-party commercial operators who wish to use it, for example, to sell their goods and services. That's probably going to be a relatively simple thing to document, because when talking there about intellectual property licenses, the purpose of the subsidiary is essentially to act as a mechanism by which the license income is received from the third-party commercial partner, and then the profits deriving from that are then paid up to the parent charity. At the other end of the spectrum, you could have a trading subsidiary which is carrying out very substantive, very significant, perhaps potentially quite complex trading activities. And I can certainly think of a number of examples of charities, who with turnover in the many millions, where actually more than 50% of their income overall is generated by a trading subsidiary. And that's obviously going to be quite a different situation in terms of, for example, the role played by the directors of the trading subsidiary, the kind of documentation that's going to be required in order to ensure that the trading subsidiary is set up correctly and then operated on the correct basis. I'm just going to talk a little bit about how one goes about establishing a subsidiary. And I mentioned already that the key document is its articles of association. Those are typically going to be in a fairly standard form for a commercial company. And we'll make it clear, of course, that the parent charity is the sole shareholder or sole member, depending on how the company is established. The charity is obviously going to need to be able to identify and appoint directors of the subsidiary. So there is always a question about who should act. And again, the Commission's guidance is relevant here. What they say in CC 35 is that the board of directors of the trading subsidiary should include at least one trustee who's not also an employee of the trading subsidiary, and at least one director of the trading subsidiary who is not a trustee or employee of the charity itself, and that's again reflecting that principle of independence that I mentioned, but also to help facilitate the management of conflicts of interest. Other relevant questions, I think, in terms of identifying and appointing directors: how can they gain access to indemnity insurance? So typically the parent charity's trustees will have access to directors and officers or trustees indemnity insurance. And I would expect the directors of a subsidiary to want to be able to benefit from that. There's also going to be a question, I think, about the kind of governance support that ought to be available for the directors of the subsidiary. Because it is an independent entity, it is important that the directors have their own meetings, they make their own decisions. There are, I think, risks if that is not clearly the case, and I'll come back to talk about that as a risk a bit later on in the webinar. There are two other potentially key documents that need to be put in place in relation to a subsidiary. The first is what we would typically call a shared resources agreement. So between the charity and the subsidiary, and I'm going to talk in a minute about what that might cover. And the second is a deed of covenant by the subsidiary in favour of the parent charity, which essentially relates to the repatriation of profits by the subsidiary to the charity. And then the final aspect, I think, is to think particularly on establishment, but also terms of ongoing access to working capital, it is the whole question of how a trading subsidiary should be funded. So in terms of the shared resources agreement, which I mentioned, the purpose of this is essentially to ensure that the subsidiary has access to the services it will require from the parent charity in order to be able to operate. It is really important that that is on an arm's length basis, just coming back to the principles I mentioned a bit earlier on. And the concept of there being a written legal agreement between a parent charity and its trading subsidiary is very much in line with the guidance on charities connected with non-charities, which I mentioned a little earlier in the webinar. So typically, an SRA will address a range of issues. So it will address the basis on which the parent charity will supply any services to the trading subsidiary in order to allow it to operate. So, for example, the services of the charity's employees, kind of back office administrative support services. It'll also typically address any licenses which the subsidiary will require in order to operate. That could be a license of the charity's property. It could, in the kind of example I mentioned earlier, where the subsidiary is going to be licensing the charity's brand to a third-party commercial partner. It could include the relevant licenses of that brand. It will also typically cover the basis on which the subsidiary pays for any services provided by the parent charity. And the approach normally taken there is that one is aiming to achieve a position where there is no subsidy by the parent charity of the activities, of the cost of the trading subsidiary's activities. And that comes back to that arm's length principle. But equally, typically, one would want to make sure that there is no profit generated by the charity, and that's to avoid any kind of tax liability arising within the charity itself if the services it's supplying do not relate to the advancement of its own objects, which will typically be the case. And then, as you'd expect, a well-drafted shared resources agreement should address issues such as data protection, if personal data is going to be shared. It should address safeguarding. Again, that will depend to an extent on what it is the subsidiary is doing in practice, but that thought should be given to that. And then issues such as anti-bribery and corruption and confidentiality. There is also an opportunity in the shared resources agreement, if relevant, for the parent charity to think about reserving certain decisions in relation to the trading subsidiary's business to the charity. This is probably going to be more relevant where you have a trading subsidiary which is carrying out much more substantive, complex activities, generating a lot of income. And it may well be the case that the parent charity takes the view that it would like to have some ability as the sole shareholder or as the sole member to reserve certain major decisions to it. So that could be, for example, a decision by the directors of the trading sub to take on a significant loan, to sell part of its business, to acquire a different business. And those are all things that could be spelled out in the shared resources agreement as requiring the prior approval of the parent charity's trustees. So not always going to be relevant, but certainly worth thinking about, particularly where the subsidiary is carrying on, as I say, more complex, more substantive operations. I mentioned also the use of a deed of covenant. And this is essentially, it's a fairly straightforward document. And the main purpose is to create a legal obligation on the subsidiary to return its annual profits to the parent charity. Now, this isn't always required. In my experience, some charities will put a deed of covenant in place, some will not. There was a relatively recent change in the accounting treatment around the recognition of donations. And that has, in our experience, seen more charities put in place deeds of covenant, because if a deed of covenant is in place, that enables profits generated by the trading subsidiary to be recognised in the charity's accounts in the year in which they arise. And that's because the covenant creates a legal obligation on the subsidiary to return the annual profits to the charity. Just to point on the deed of covenant, it does need to be drafted quite carefully, and that's because it is possible for there to be differences in the way in which profits of the subsidiary are calculated for tax purposes and for accounting purposes, and it is possible for discrepancies to arise. And this relates really to a company law point about the amount of profit which is, and the phrase is, available for distribution by a subsidiary back to its parent charity. And that's a potential risk area, which I'm going to come on talk to shortly. I mentioned funding. This is, I think, a particularly important aspect, both in terms of the initial investment that a charity may wish to put into its subsidiary, but also in relation to any further investment which may be required to meet the subsidiary's working capital requirements. And of course, those requirements will depend a great deal upon the nature of the activities that the subsidiary is actually carrying about. Just thinking back to that spectrum of activity that I mentioned earlier on, where you have a subsidiary which is really put in place to license, its requirements for working capital may be fairly limited. If it's carrying out much more substantive operations, then its working capital requirements may be much more significant and needs to be thought about in more detail. In terms of the way in which funding can be put into a subsidiary, there are essentially three options. The first is that the parent charity could make an equity investment, so it could subscribe for shares in the trading subsidiary. Now, that's only going to be possible where the subsidiary is established as a company limited by shares and not by guarantee. So that, as I said earlier on, that may well be relevant to the basis on which you set up a subsidiary as a share company rather than a guarantee company. The second method is by way of loan. Typically, I think in my experience, that's a loan by the parent charity to the subsidiary, could potentially be by a third-party lender, by a bank. And then the third option is essentially retention of profit. And that is something that is obviously possible. The implication of that, of course, is that to the extent that profit is retained by the subsidiary, it's not going to be able to donate them up to the parent charity, and there will be a corresponding tax charge. Now, that doesn't mean that it's not possible for a subsidiary to retain profit, but it is obviously a relevant consideration in thinking about the funding position generally. So in terms of equity investment and loan investment, it's important to be aware that these need to be what are called approved charitable investments. That's the revenue's way of describing them. There are two key components to that, really, which the revenue would, if necessary, need to be satisfied about. Firstly, that the relevant investment, whether subscribing for shares or making a loan, is for the benefit of the parent charity. And I'll come back to that in a second. And secondly, that it's not for the avoidance of tax. Now, that's important because if an investment that's made by a charity in a subsidiary is not an approved charitable investment, it will be what's called non-charitable expenditure under the relevant tax legislation. And that can lead to what is essentially a pound-for-pound restriction on the charity's ability to claim the whole range of other exemptions and release from tax on which it's for which it's eligible. So it can have a direct financial implication. So important that we think, therefore, about what will constitute an approved charitable investment. And the key principles really are, it needs to be a properly taken investment decision. And it needs to be for, in this context, the financial benefit of the parent charity. And what's clear, certainly from the revenues guidance, is that they would expect the trustees of a parent charity to assess the investment they're making in pretty much the same way as they would assess any other investment that they're making. So they need to be thinking about the principles of suitability and diversification, which apply to investment powers generally. They would need to be thinking about the kind of financial information they need about the proposed investment. They need to be thinking about projected income, expenditure, level of profit that may be returned. They also need to be thinking about reasonable steps to limit the parent charity's exposure to risk. So, for example, if they're thinking of making a loan investment, typically they ought to at least think about whether or not it's possible to take security for that loan. I think I would say that in practice, it's often quite a difficult thing to do, particularly in the early years of a trading subsidiary when it may have very few assets actually to grant a charge over, which provide any benefit to the parent charity. But it is important that that is considered. There's also an obligation to potentially to take advice from someone who understands the investment decision in relation to the proposed investment. That's not always the case. The revenues guidance is that that advice should preferably be independent. Again, I think this very much depends upon the level of investment that that the charity is thinking about making. Clearly, if it's a much larger and a more significant investment, there's probably going to be a greater onus on taking advice. It's not an absolute requirement, but it is clearly something that needs to be considered. And as ever with these things, it's really, really important that the investment process and the investment itself is really clearly documented. So it will be important that there is a clear record of the charities trustees thinking about the investment, and it would also need to be very carefully and properly documented. So if, for example, it's a loan, there will need to be a very clear loan agreement which spells out, for example, the market rate of interest that's paid, the repayment terms, and obviously if security is available and relevant, then the basis on which security is going to be provided. Technically, an approved charitable investment requires a claim to HMRC. Our understanding is it's not possible to seek a pre-clearance. Typically, that claim will be made by ticking a box in the parent charity's tax return. Also worth flagging, of course, that in thinking about the form of investment that's made, that equity investment is typically regarded as higher risk than a loan investment, and that's really because if the subsidiary is in financial difficulties, if it becomes insolvent, then the shareholders will rank behind loan creditors. So that's going to be quite a relevant consideration. And then just to come back again to this whole question of retention of profit. So if the main driver of setting up a subsidiary is to avoid and to limit the tax payable on the non-primary purpose trading activity it's carrying out, then retention of profit, which will generate a liability tax, runs counter to that. But as I've said, I think it can be justified in some circumstances. That there is no bar on a parent charity's coming to the trustees coming to the view that actually in the circumstances the subsidiary is in, it is better for it to retain profit than for the parent charity to put in, for example, additional equity or loan investment. So I'm going to move on to talk a little bit about some of the key risk areas, and these are things that really we see arising in practice. I think one key area to think about is loss-making subsidiaries. We saw a number of examples of this, actually, particularly during the pandemic, particularly for trading subsidiaries which were set up to, for example, provide access to charities' facilities when the COVID restrictions meant that that couldn't happen, and therefore a subsidiary's income was very restricted. And where you do have a subsidiary which is loss-making, it's obviously potentially quite some quite difficult decisions for the parent charity's trustees to make. Should they put in additional finance and investment? Can they justify that where the subsidiary is loss-making? Just coming back to that whole concept of what is an approved charitable investment, is it a good investment for the charity to be putting further money into a loss-making activity? But obviously, one can see in those sort of circumstances, the trustees may feel, a concern about the subsidiary perhaps going insolvent, with potential damage to the charity's reputation if that happens. So again, a risk area. I think in terms of that one, it really comes back to making sure that there is a very clear decision-making process by the trustees around any further investment into a loss-making subsidiary, so that they can justify that if it is ever challenged by HMRC or the Charity Commission. Kind of linked to that is the second risk area, is the whole question of the parent charity being asked to give a guarantee of the subsidiary's liabilities to a third party. That might be because, again, it's either loss-making or it is experiencing financial difficulties more generally. Could be that a third-party customer, for example, or another lender says, well, we'd like access, please, to the parent charity's assets if the subsidiary defaults on its obligations. And the point I just wanted to bring out there is that the question of a charity guaranteeing the obligations of a third party is not particularly straightforward. There is a relatively elderly case now which says that actually it's not possible for a charity to guarantee the obligations of a third party. I think we tend to take the view that that case was decided quite a long time ago, and that in the context of the relationship between a parent charity and its subsidiary, it is potentially possible to distinguish that case. But the whole area of giving a guarantee is clearly important, because it potentially drives a coach and horses through those principles of independence and arm's length nature of the relationship, which I described a little bit earlier on. And of course, it potentially puts the assets of the parent charity at what may be, in the Commission's terms, significant risk. So worth thinking about. And one point which I looked at fairly recently is also the question of, actually in an audit context, there is the ability under the Companies Act for a parent company to essentially guarantee its subsidiaries' obligations using a statutory mechanism. That, as I understand it, may reduce audit costs. But again, because that is a guarantee, it needs to be thought about very, very carefully. It's one of those areas, I think, where typically trustees will probably want to take some advice. Another risk area for me is what I've called muddled governance and administration. This comes back to that point I was talking about earlier on, which is it is important, given the independence of the subsidiary, that, for example, its directors have meetings, that they clearly make decisions in their capacity as directors, that the subsidiary is administered on a basis which recognises that it is an independent entity. And I've certainly seen examples in the past where, for example, that hasn't really happened. So, for example, the directors of a subsidiary haven't actually had the meetings that are required by the articles. It's not clear where the subsidiary is contracting with third parties, that the contracts are actually in the name of the subsidiary as opposed to the name of the parent subsidiary. And that can raise a range of risks. One of those is that in certain circumstances, particularly in the context of a subsidiary's insolvency, that someone may seek to argue that the parent charity is actually what's called a shadow director of the subsidiary. In other words, while not formally appointed, it is actually the entity which is making all of the decisions. And in an insolvency context, that potentially allows creditors to claim via an insolvency practitioner against the parent charity. So that's one area of risk. The other area of risk for me is really around the duties owed by the directors, which are pretty clear under both company law and case law. And if the directors aren't, for example, meeting regularly to look at the trading subsidiary's activities, to monitor its finances, to monitor its activities, that there is a risk that they will be in breach of those duties. And again, that might be something that comes out in the course of, for example, an insolvency of the subsidiary, when typically an insolvency professional will be looking at the way in which the directors had discharged their duties prior to that insolvency. So again, another area of risk that really can arise if there isn't a really clear approach to the governance and administration of a subsidiary. It's also really important just to bear in mind the rules on conflicts of interest, conflicts of duty. This can be particularly relevant where the board of a subsidiary includes, for example, one or more trustees of the parent charity, and by way of example, the subsidiary is in financial difficulties. There will obviously be a conflict for those individuals. From the subsidiary's perspective, they would be looking to the parent charity to provide probably further investment. That may not be the correct decision from the parent charity's perspective. So that kind of conflict of interest, conflict of duty needs to be very carefully monitored and acknowledged and addressed if it becomes clear that the conflict could disrupt the decision-making process by the charity's trustees or the subsidiary's directors. And the final risk area I wanted to mention is something that was highlighted in some Institute of Chartered Accountants of England and Wales guidance, which was issued a few years ago now. This relates back in a way to the point I made about the deed of covenant. Technically, as a matter of company law, the subsidiary can only make payments of profit, donations of profit back to the parent out of what are called profits available for the purpose. There's quite a technical analysis of that. But the risk issue is that if there are insufficient profits available for the purpose, but the subsidiary makes a donation to the parent charity anyway, and that could be, for example, because the deed of covenant is not drafted correctly, then there are some implications of that. It's essentially an unlawful distribution. The charity would have an obligation potentially to repay the amounts it's received from the subsidiary. There's also potentially personal liability for the directors of the subsidiary in that context. And of course, there will also be an adverse tax implication. So it is really, really important that certainly deed of covenant is drafted with those points in mind. And it's also important, again, that the directors have a clear understanding of what profits are available for distribution in order to avoid any payment to the parent charity being unlawful. There is a link to that guidance at the end of the slides. So just to emphasize really that charities may set up other kinds of subsidiaries for a range of activities. Sometimes subsidiaries are set up in order to carry out primary purpose trading activities, where there is some rationale for actually separating those activities out from perhaps the main activities of the charity. That could be for good risk reasons. As I mentioned earlier on, there's also the possibility that a charity may enter into a joint venture with other third parties. And then, of course, as I've also said, charities may themselves have charitable subsidiaries, and the relationship between a parent charity and a charitable subsidiary is different in many respects to the kind of relationship that I've been describing in this webinar. So the source material, charities and trading, that's the Charity Commission's guidance, CC 35, as I've said. Not that long, I think always a very helpful source, very helpful thing to read. The second link is to HMRC's guidance on non-primary purpose trading by charities and their subsidiaries. The third is the guidance I mentioned for charities with a connection to a non-charity, that's Charity Commission guidance. And the fourth link is to that ICAEW report on unlawful distributions, which I mentioned a little earlier. So I'm going to end the slideshow now. And see if we have some Q&A. So I'm just going to take a minute just to have a quick look at some of these questions, if that's okay. Thank you very much for submitting them. First is more a comment than a question. Isn't it somewhat contradictory that executives of charities are not morally permitted to be a trustee of their charity without seeking CC permission, but it is permitted and common for them to be a director of their trading subsidiary? Yes, I mean, I guess, but that is perfectly possible under the law as it stands. Because the trading subsidiary is not a charity, it is able to it is able to appoint those people as directors. I think probably for me the key point is around just being very aware of any conflict which arises as a result. It's probably also worth saying that in my experience, it's often quite difficult to find people who wish to act as directors of a trading subsidiary. So people may, of course, be quite keen to become the trustee of a charity. But if someone were to be asked to act solely as the director of a trading subsidiary, that they may be a bit more reluctant to do that. Next question. In a shared resources agreement, is there any guidance about when a grant of a license for the trading subsidiary to use premises of parent charity will be considered a disposition of charity land requiring Charity Commission approval? CC 35 is not clear. It notes that the granting of a lease will and the granting of a license may constitute a disposition. Do you have a view on when granting of a license would amount to a disposition? I think the short answer is that the grant of a true license is not a disposition for the purposes of the Charities Act and does not require the consent of the Charity Commission. The reason I say the grant of a true license is that it is possible to grant a license which has the effect in law of being a lease if the trading subsidiary acquires, I think the phrase is, exclusive occupation of the premises in question. But I think in my experience, that's a very rare argument to be made. It would be an argument that would have to be made by the trading subsidiary, and there's not usually anything in it for the trading subsidiary to make that argument. So I think I would typically expect a shared resources agreement to include a license of any premises, and as I've said, I don't think that requires Charity Commission approval. Thank you. So next one, for a significant trading subsidiary, can the funding relationship be structured so that all profits could be paid up to the parent charity, but that the parent funds ongoing capital investment requirements of the subsidiary? That's a very good question. There's been some commentary on this in the past, something actually I looked at for a client relatively recently, because some years ago, certainly the revenues position was that they would look carefully at what they called circular funding arrangements, which is really what you've described there. Essentially, all of the profit is stripped out, paid out to the parent charity. Parent charity then, for example, makes loans back to the parent charity or subscribes for equity in the parent charity to fund it. As I say, the Commission said they would look carefully at that. They were never very specific about on what basis. I think they were probably thinking about whether that, when one steps back, that forms some kind of tax avoidance arrangement. I would say I think that is a pretty low risk. There was, I think, a case in which the revenue started to challenge that, which they didn't succeed on. So I think that risk is probably relatively low as things stand. But of course, if you're taking money out and then putting back in, we're just straight back into that argument about the basis on which you make an approved charitable investment. So for me, that would be the focus. The money comes out, but then when you're thinking about, well, how does the money go back in? You've got to be thinking very carefully about, okay, is this a good investment of the charity's funds? Please confirm the main potential benefit is the removal of corporation tax liability for the charity, which relates to non-primary purpose trading. Yes, that is the main potential benefit. Other benefits could include, in certain circumstances, particularly where you have one of the kind of more substantive complex trades I mentioned, that you give a board of directors of the subsidiary much more governance, operational focus on that activity. Perhaps they're able to run it more effectively as a result. But you're right, the main benefit is corporation tax exemption from corporation tax liability. I'm just scrolling through a few other questions. Would you say that income from child placement payments to a charity which runs children's homes is primary purpose trading income? I probably don't know quite enough about the structure around that, but I would say that if the charity's objects in running children's homes is, for example, to provide education or care, then the income which it receives in order to provide that education or care, for me, would be primary purpose trading income. Obviously, one would need to, I think, a bit more about specifics around that, but for me, that would fall into the primary purpose trading income pot. Please, could you elaborate on the composition of the board of directors for the trading subsidiary? Yeah, as I've said, the Commission's guidance on this is that they would expect there to be at least one trustee of the charity on the board. I think that's probably to provide some oversight from the trustee level, and then there would be at least one director of the board of the subsidiary who is not either a trustee or an employee of the parent charity. As I said a bit earlier on, I think my experience in practice is it's often quite hard to recruit what I would call external independent people. That will, though, depend to an extent on what it is the trading sub is doing. As I said earlier on, if it's a substantive trading activity, you may be better placed to do that. The ideal, I think, is that you do have at least one independent person who acts in that way, but recognizing that it's not always very possible in practice. Also, what are the risks, implications on procuring services on behalf of the trading subsidiary if it only just been set up and doesn't have a bank account or personnel? Okay. In terms of procuring services, again, I think that's actually, if the trading sub is going to need those services, and there is a decision that it's important to go out and procure those before you've got too far down the road of, as you've said in the comment, in the question of setting up a bank account or it having personnel, then I think that's one of those things that the charity could agree to do. It would be essentially a service provided for the trading subsidiary. So it's the kind of thing that one would want to cover off under the shared resources agreement. So it's a service that the charity would provide. And then in terms of the procurement itself, obviously it would need to be very clear that whatever is being procured on behalf of the trading subsidiary. So you would need to look quite carefully, I think, about the detail there. What is your guidance on trading subsidiary name? How different from the charity name should this be? I think that's very much a question for the trustees to think about in the context of what the trading subsidiary will do. If it's an activity that is very closely allied to the charity, then there is no objection fundamentally to it using a name which is very, very similar. And I certainly see that a lot. So it might, for example, be name of charity Enterprises Limited. And that's certainly something that is, as I said, done a lot. If the trading subsidiary is carrying on something which is really quite different from the parent charity itself, you know, it's very much a substantive profit-making venture which is operating in a different market. Really, again, you probably want to think about whether that could be branded differently. And again, there's no objection to that. I suppose one key point to think about from the trustee's perspective is there any kind of reputational risk associated with the name? So if, for example, the trading activity is considered to be perhaps at the higher end of the risk scale, and there is the possibility of it experiencing financial difficulties, whether that will have any adverse reputational impact on the charity itself. Can the charity and the trading subsidiary be in the same VAT group, given the concern and charity giving a guarantee because the joint and several liability of the VAT group members for the tax? That's a very interesting question. The short answer is they can be in the same VAT group, as I understand it, and I've certainly seen examples of many charities and their subsidiaries that are in the same VAT group. Particularly because that will avoid generating any kind of VAT liability on services supplied by the parent to the subsidiary. But it's an interesting question about the joint and several liability. I think that would be one of those situations where the rule against guarantees would need to be, not the rule, but the case law which suggests it's not possible to give a guarantee would need to be thought about and distinguished. So I think from the trustees' perspective, they would be looking at the overall financial health and financial return to the charity of the ability of mitigating any unrecoverable VAT liability. Thank you for all the questions. I'm sorry, I'm just scrolling through a few more. I hope I'm not missing too many. If a parent charity wants to buy goods from its trading subsidiary, and one of the trustees is also a director at the trading subsidiary, how should this be handled in terms of any potential conflict of interest? Or does it not matter as it's being its own trading subsidiary? No, it does matter. So that conflict of interest would need to be addressed because obviously the individual in question is both a trustee and a director. There is a transaction between the subsidiary and the parent charity. So that person will have a conflict. Typically, the answer would be that I think that the individual would participate as a director of the company, having declared their conflict, because its articles would enable that to happen and would not participate as a trustee in relation to the decision on behalf of the parent charity.